Welcome to our presentation for Environmental Sensitivities Awareness Day. I am presenting on behalf of Michel Gaudet. We hope that this presentation will be useful to you. Please share it widely. The title of the presentation is Environmental Sensitivities Legal Aspects. Michel Gaudet is the Executive Director and Vice President of the Environmental Health Association of Quebec. As you have heard from the presenters and also from your own personal experience, environmental sensitivities can be very disabling and often leads to exclusion and sometimes even extreme isolation. Good management tools, starting with avoidance, can help you retain your place in society and even allow you to re-enter society. So, do you have any rights in order to do this? Are you protected in any way? Is there anybody out there who has already deemed that you do have rights? If so, who are they? What do they say? What can you do for yourself or others who suffer like you? This presentation will address the Canadian federal jurisdiction and the Quebec provincial jurisdiction. Welcome to the presentation on the legal aspects of environmental sensitivities. The Canadian and Quebec Charter of Rights recognizes environmental sensitivities as a handicap. In both cases, harassment on the basis of a handicap is prohibited. Prohibition of harassment because of a handicap. What this means is that environmental sensitivities are recognized as a handicap. Therefore, the harassment of a person who has environmental sensitivities is prohibited under the Charter. If you are harassed because of your sensitivities, you have the right to file a complaint with the Human Rights Commission in Quebec. Contrary to the Canadian Human Rights Commission, this right is not restricted to the workplace only. It is very important for you to find out how you are covered under your province or country's human rights commissions. As we go along in the presentation, you will get ideas for the questions you need to ask. A policy on environmental sensitivities was approved on June 15, 2007 and reviewed on January 2014. Individuals with environmental sensitivities experience a variety of adverse reactions to environmental agents at concentrations well below those that might affect the average person. This medical condition is a disability, and those living with environmental sensitivities are entitled to the protection of the Canadian Human Rights Act, which prohibits discrimination on the basis of disability. In 2006, the Canadian Human Rights Commission commissioned two reports, one on the medical aspect of environmental sensitivities and the other on the legal aspect of environmental sensitivities. Based on these two reports, the Commission adopted a policy on environmental sensitivities on June 15, 2007 and reaffirmed it on January 2014. The Canadian Human Rights Act protects employees where the employer has a federal charter. For example, the offices of the federal government and all its agencies, banks, communication companies, airlines, railroads, etc. This standard is recognized and applied more broadly based on the merits of medical and legal supporting documents. The Canadian Human Rights Commission will receive any inquiry and process any complaint from any person who believes that he or she has been discriminated against because of an environmental sensitivity. Like others with a disability, those with environmental sensitivities are required by law to be accommodated. The Canadian Human Rights Commission encourages employers and service providers to proactively address issues of accommodation by ensuring that their workplaces and facilities are accessible for persons with a wide range of disabilities. Successful accommodation for persons with environmental sensitivities requires innovative strategies to minimize or eliminate exposure to triggers in the environment. These may include developing and enforcing fragrance-free and chemical avoidance policies, undertaking educational programs to increase voluntary compliance with such policies, minimizing chemical use and purchasing less toxic products, and notifying employees and clients in advance of construction, renovations, and cleaning activities. Such measures can prevent injuries and illnesses and reduce costs and health and safety risks. In November 2011, the Environmental Health Association of Quebec, with the help of Professor Rachel Cox, Professor in Legal Studies, Faculty of Law at the University of Quebec in Montreal, UQAM, made a request to the Quebec Human Rights Commission to state an opinion on the subject of environmental sensitivities. Their response was that, and I quote, "The definition of the word handicap in the Quebec Charter of Rights and its interpretation by the courts upon which we base our own decisions are sufficiently broad to be applied to people suffering from environmental sensitivities. The Commission has put much effort into ensuring that this definition be very general in order to protect and defend the rights of as many people as possible. Therefore, our approach is not handicap specific in our notices aimed at improving recognition of human rights. It is rather in the course of our investigations that we rule on particular situations according to the circumstances of each one." You may suspect or know by now that you could be suffering from environmental sensitivities. You cannot tolerate different products and substances such as chemicals such as perfumes, cleaners, petrochemical products, etc., mold, electromagnetic fields, and maybe after hearing the presentation of Dr. John Malott, you probably realize that you could be suffering from this condition. There are many other sensitivities besides chemical, mold, and electromagnetic, such as sound, light, vibrations, etc. This condition can seem overwhelming as there are so many issues to address to try and manage your condition. Your first step should be find a doctor, get a diagnosis. Finding a doctor who would give you a diagnosis would be an important step to take. But what happens if you cannot find a doctor who can give you a diagnosis? You must keep looking. Contact support groups, even if they are in different provinces or countries. You never know how information given to you could help you find a doctor. Even providing information on the condition to your family doctor could be a good start. Resources are always useful. Even though, as you will see later on, there have been legal battles won in Quebec, it is hard to find a doctor to give you a diagnosis and stand by you. What is the role of your doctor? He or she has to be ready to stand by you, be knowledgeable about your illness, fill forms if required, communicate with the insurance company or other institutions, write letters requesting accommodation to support your illness so that you can continue working or be able to be physically present in social settings, for example, your library, health clinics, lawyer's office, etc., and appear in court on your behalf, etc. As you have seen, you do have legal rights. If work exposures have triggered this condition, or if you are already sensitive and products or substances in the workplace make you ill, you have the right to ask for reasonable accommodation. We will speak of reasonable accommodation later. You also have the right to dignity and a workplace free of harassment. When you decide to exercise your rights, you should be aware that it is a long process. You have to find health professionals who are willing to testify. You must be mentally prepared to accept that the diagnosis will often be challenged. The process of exercising your rights may be daunting. You have to literally ask for changes in people's behavior and choice of products. The way you make this request, the records you keep, and the support system you build around you could determine your success. After all, if you keep working in a healthy environment for you, everyone will benefit and you will be able to be self-sufficient independent, and ultimately not land on the support system of the government. In some instances, it has taken as long as 3 years for the settlement of a case. So, you suffer from environmental sensitivities and could have an employer or not. As I have said before, the first step is to get a diagnosis from a medical doctor. Why is this important? As you can see, it could very well be the cornerstone for the success of all your requests. For example, it can be used to receive income tax credits on items that you need to manage your health that are accepted as medical expenses for income tax. These could be air purifiers, air conditioning, furnace, etc. A doctor's diagnosis can also be used to obtain a disability tax credit from Revenue Canada, which will give you an additional non-refundable tax credit. A diagnosis can also help you receive accommodation at home, for example, from your family, and in the social setting, for example, with your friends, at the library or community center, or with your entourage. It could be also used to get accommodation at school. Often people with this condition get severely isolated because they cannot enjoy public spaces such as libraries, restaurants, classrooms, and they most often drop out of activities which they used to enjoy. This often leads to isolation. A diagnosis is also useful if you do not have treatment available in your province and you must travel to another province for treatment. For example, Nova Scotia or Ontario. For this, you need a letter from your doctor stating that these treatments are not available in your province. You can then claim costs incurred for items such as travel and meals in your medical expenses for a tax credit. Remember to check with Revenue Canada for the amounts of deduction allowed for each item. Similar expenses can be accepted within your province depending on the distance you have to cover to receive these treatments. Provinces could cover some costs of the visit to a doctor when you have to go to another province. Find out from your health ministry what is allowed and remember to get the forms before you leave for treatment so they can be filled out properly by you and sent in on time for a reimbursement. In Quebec, you have 1 year to send in your request for reimbursement. The following is for the province of Quebec. If you are from elsewhere, find out your rights for your jurisdiction, ask for help, do not delay as claims and appeals are time sensitive. If you have an employer, there are 2 different aspects. Aspect 1 is work-related. In Quebec, if you are a salaried worker, whether you are unionized or not, if your illness is in relation with an exposure at work and you have to stop working because of your illness, then you can make a workman's compensation claim at the CNESST, formerly known as the CSST. The claim must be done within 6 months of a working accident or 6 months from the date of receiving your diagnosis when it is confirmed and you know that your illness is work-related. In the case of a severe exposure after a toxic product spill, this could be considered a work accident. On the other hand, if it is a daily exposure due to your work, it could be considered an accident or an illness due to your work. If you make a claim later than 6 months, you must have a very good reason. For example, you received your diagnosis and had a heart attack soon thereafter. You were therefore not able to make a claim on time. If the CNESST rules that your illness is linked to an exposure at work, you will be entitled to receive a compensation of replacement of your revenue at 90% of your net salary while you are not working. Furthermore, once you have recovered but you still cannot go back to work, in some circumstances, you may have the right to have training for another type of job. In order to support your claim, and again I will state, you need a diagnosis from a medical doctor, you have to prove that your illness is related to your workplace. It is useful to request your employer for the material safety data sheets for the products that you work with or that you have been exposed to at work. There could be many possibilities for your illness, such as working with chemicals such as glues, tints, solvents, etc., or work being done at your workplace such as renovations, roofing, new carpets installed, cleaning products used, etc., or even if your windows are open and there is asphalt work going on outside, such as road work or work on the parking lot, or if the air intake of the building allows these chemicals in, or even if there is a vehicle idling by the air intake of the building, or if you are exposed to mold in the workplace and you become ill, you could claim that your illness is related to an exposure at work. This is just a recap to define a work-related accident and a work-related illness. A work-related accident is a single acute exposure or a series of low-level exposures caused by work itself or the work environment leading to an illness that is disabling. A work-related disabling illness caused by work itself or the work environment is related to the risks inherent at the workplace. A work-related accident or an illness might be defined by the circumstances. For more information, refer to the guide on jurisprudence found on our website at www.environmentalsensitivities.com. If you are unionized, usually, your union representative will guide you to file a claim to the CNE-SST. It is important to inform your union that you have had an accident at work because, should the employer contest the incident, your union will need to file a complaint and you will need to give a letter of permission to your union so that they can access your file at the CNE-SST in order to help you. In some cases, your union may have to file a grievance according to your collective agreement. On the other hand, if you are not unionized, you are on your own to file a claim to the CNE-SST and to fight your employer if they contest your claim. To get help, see the resource section at the end of the presentation. Also, contact a volunteer group for help, but remember to state your needs in advance. Your needs could include that the volunteers are scent, fragrance, smoke-free, that they switch off their tablets or cell phones when they are with you, that they are willing to meet in a place that does not make you ill, etc. If meeting places are hard to find or the volunteer cannot be sent free due to circumstances, for example, the family does not want to change, then working through telephone and emails could also work for you. If your claim at the CNE-SST is denied, don't accept the decision. Remember that you have 30 days to ask for a revision of your claim. If the decision of your claim is still unfavorable, you have 45 days to file an appeal to the Administrative Labour Commission. Here, a first step will be a mediation. If there is no result, there could be a hearing. At this stage, there will be medical experts, expert witnesses, your testimony presented, etc. Usually, a decision will be made within a year. If your claim has been accepted by the CNE-SST, but the employer goes into appeal, you will be paid by the CNE-SST for the duration of the process. If you win, then the CNE-SST payments will carry on. If you lose and the employer wins, then the payments will stop. The advantages of CNE-SST. If your claim has been accepted by the CNE-SST and you cannot work, you will receive 90% of your net salary, which is non-taxable. If they establish that you are able to work, but that you have a percentage of disability, you will receive a compensation according to the percentage of disability established by the CNE-SST. This is referred to as bodily injury scale. You may also be entitled to retraining for another type of work. If your claim has been accepted and you go back to work and you have a relapse, you can file a claim again for relapse or aggravation. It is important to note that prior to 2002, all decisions for environmental sensitivity were unfavorable. However, between 2002 and 2011, there were 11 favorable decisions and 3 unfavorable decisions. This is an indication that there is more awareness of environmental sensitivities. This is clearly an improvement since between 1992 and 2002, all decisions were unfavorable. If you have an employer, aspect 2. You have an employer, but what happens if your illness is not work-related? You cannot file a claim with the CNESST since your illness is not from an exposure at work. However, you react to your work environment and get ill. If you have a diagnosis of environmental sensitivities and exposures at work are making you ill, is there anything you can do? Yes, you don't have to wait until you cannot work at all to invoke the right to accommodation. Since the condition is recognized by the Human Rights Commission as a handicap, like any handicapped person, you are entitled to a reasonable accommodation under the law. You have the right to ask for accommodation in the workplace. You can make this request even though your sensitivities were not triggered in the workplace. For example, you did not become ill from the new carpets that were installed or other renovations or the products used at work, etc. In other words, what made you sensitive was not an exposure at work. However, you now suffer from environmental sensitivities and now cannot tolerate the environment at work. Perfumes, cleaning and maintenance products, renovations, personal care products, air quality, mold, etc. all make you ill. If you are in this situation, you can ask for accommodation, and it is important for you to take some steps and to do some research before you do. For example, keep a record of all your exposures and symptoms. See the URL on the upcoming slide to help you. Also, the sample letters on the website could help you write your letters requesting accommodation. To be most effective, please view the website mentioned on the upcoming slide, which provides various accommodations and how to implement them. For instance, these accommodations could include carpet removal, staying at home during renovations, working from home or at an alternative location, having a scent-free environment policy adopted and advertised at work, that is, no perfumes used anywhere, eco-cleaning products, visitors are advised to be scent-free, etc. Remember, you need not be incapable of working to invoke this right. Here are the URLs for the form to record your exposures and symptoms, and also sample letters on how to request for accommodation. If you need help to establish a scent-free environment, visit the website of the Canadian Centre for Occupational Health and Safety. If you request accommodation, everyone is obliged to participate to provide a reasonable accommodation, such as the employer, the employee, and/or the union. If you are unionized, write to your union to explain the situation and your needs. They have to accompany you to the employer to request accommodation. If the employer refuses the accommodation and you are unionized, file a grievance within the deadline provided by your collective agreement. If your employer denies your demand or your grievance, you then go into arbitration. If you are unionized, you cannot file a complaint to the Human Rights Commission. If you are not unionized, file a complaint with the Human Rights Commission. It is essential that the person who is sensitive participate in identifying the accommodation to be provided. Once a plan has been established conjointly, the person with environmental sensitivities has an obligation to try the proposed measures. Accommodation is not rigid or one size fits all. It should be flexible to suit the needs of the person or adapted to reflect a change in the situation. For example, what if there are established accommodations in place, but then a printer is moved next to the person's workstation. The printer or workstation will have to be moved to accommodate the person. If it is impossible to achieve the required accommodation, the person may have to quit the employment. What if your union refuses to represent you or cooperate with you? According to the Labor Code, a union must represent its members. The law is very clear. If they do not help you, then file a complaint with the Administrative Labour Commission within 6 months. The Commission will render a decision. If the ruling is in your favour, your union will have to support you. This entire procedure does not seem to be easy. You have to fight with your employer, with your union, sometimes with your doctor, if you can find one. It is very important to build support around you so that you are able to do this. And you have to do all this while you are ill. We know that most often this is very difficult, but people have persisted and there have been positive outcomes. To recap regarding a request for accommodation in the workplace, in the case of a failure to respect the right to accommodation, what steps should you take and when do you take them? If you are unionized, you cannot file a complaint with the Human Rights Commission. You must file a grievance, and the timeline is according to your collective agreement, which is made between your employer and the union. However, if you are not unionized, it is important to respect the timelines and the steps one must take to file a complaint. For the Quebec Human Rights Commission, the deadline to file a complaint is 2 years from the refusal to accommodate received in writing. Following that, there will be an investigation and mediation, followed by a hearing in front of the Quebec Human Rights Tribunal. In the case of federal jurisdiction, a complaint must be made to the Canadian Human Rights Commission within 1 year of the refusal to accommodate in writing. This will be followed by an investigation, then mediation, and a hearing in front of the Canadian Human Rights Commission. It is important to remember that you do not need to reach a point where you are unable to work in order to ask for accommodation. If you have an employer but you are not unionized, you must make the request for accommodation yourself in writing. As we have said before, all communication must be in writing or followed up in writing so that there is a paper trail to support your request and the response you have received. In order for your complaint to be accepted by the Human Rights Commission, you most likely have to hire a lawyer to file your complaint. Alternatively, you could find a group to help you do this. Contact local non-profit groups to get help. It is important that you are clear with volunteers about your health condition and the accommodation you need for meetings, including meeting spaces, etc. You could provide some information on the condition and provide some alternatives to help people to be scent-free and/or switch off any wireless technology or equipment that makes you ill. Try working through email and telephone. It is not easy, but don't give up. As we have said before, you have the right to be accommodated. You need not be incapable of working to invoke this right. In fact, you should ask for accommodation before you become incapable of working. What happens if your sensitivities are not work-related? So here I would like to demonstrate the importance of accommodation and respect. The following persons are actual members of our group. For their privacy, their names have been changed. Marie was exposed to pesticides at a young age and suffered environmental sensitivities as a result of this exposure. From the start, she received complete support from her family, neighbors, doctor, and when she was ready for work, she received the same support from her employer. This support included a scent-free policy at work, air purifiers were installed, ecological scent-free cleaning products were used, and she was allowed to work from home when she needed to. On the other hand, Sophie had it rough from the start. She too was exposed to pesticides when young, and although she had support from her family, her neighbors refused to stop using pesticides, and so she became homeless. Her doctor labeled her as having a psychological illness, and although she was highly trained, she was refused accommodation at work. All her requests were refused. She was harassed, ridiculed. Often her colleagues and even friends ganged up against her. Harassment included the use of excess perfume in her presence. She was often told that her condition was all in her head. Being ill and being exposed to this abusive treatment was too much for her. Her health continued to get worse to the point where she had to quit her job. All avenues for remediation failed, and in spite of her specialized training, she ultimately landed on the social welfare system. If you fail to get accommodation, or even with accommodation your health continues to get worse, you may have to stop working. If you have salary insurance for disability, you must file a claim to receive this insurance. You will definitely need a diagnosis and a letter from your doctor that you cannot work. The insurance company will most likely refuse your claim. If you need your insurance, you will then have no choice but to take legal action. It is preferable that you have a lawyer, and your doctor will have to stand by you. It is important to remember that often the insurer will respond that they don't recognize environmental sensitivities. It is also important to remember that you have a disability insurance and not an environmental sensitivities insurance. Therefore, if you are declared disabled, you are entitled to disability insurance. If your insurer refuses your claim, you will need a lawyer to take legal action. Ask for help in choosing a lawyer who will respect your disability. Build a support system around you in order to help and support you. In the process, the insurance company will send you to a doctor of their choice for an expertise. Remember, most likely, the doctor doing the expertise knows nothing about environmental sensitivities. Therefore, it is important to ask what expertise the insurance doctor has on your illness. This is why you should have a medical expert on your side who is proficient in environmental sensitivities. In a legal challenge, the arguments of your expert could override the arguments of the doctor hired by the insurance company. If you cannot work and your insurance company refuses disability payments to you, or if you don't have salary insurance, then your next option is employment insurance. Employment insurance is a temporary source of revenue. You must meet the requirements such as having worked a certain number of hours. This number varies across Canada between 400 to 920 hours of work. You will need a medical certificate. You do not have to prove that your condition is work-related. If the end of your employment insurance is approaching and you still cannot work, then you will have to think about social welfare as a last recourse. If your medical certificate states that you have severe constraint as to employment, your social welfare payments will be higher than the payments of a person deemed able to work. Finally, in case of a severe and permanent disability in Quebec, you could obtain a disability pension from Quebec Pension known as Régie des Rentes du Québec, RRQ, which is now under Retraite Québec. In the rest of Canada, this would be under Canada Pension Plan or CPP. Since the condition is recognized as a handicap by federal and some provincial human rights commissions, therefore, like any handicapped person, you are entitled to accommodation under the law. The employer's obligation to accommodate is to the point of undue hardship. This will obviously differ from a large employer to a small employer since they don't have the same financial means. A large employer like Bell Canada, for instance, can incur more expenses before it becomes an undue hardship than the corner store. Therefore, each case is unique. However, as we have stated before, everyone has the obligation to contribute to the process of accommodation, such as the employee, the employer, and the union if you are unionized. It is also important in every case that the accommodation is reasonable. The employer is expected to accommodate you, but not to the point of undue hardship. Remember that the obligation of accommodation constitutes an obligation for the employer to take actions and not an obligation to achieve success. For example, the employer can try everything that can be done reasonably, but if you still react with adverse health effects, that obligation ceases when it becomes undue hardship. The types of needs and accommodations are many. It is impossible to cover every situation in this presentation. Examples could be a scent-free, fragrance-free, smoke-free policy, increased ventilation and installation of air purifiers, safe removal of carpets and other irritants, use of ecological cleaning, renovation and maintenance products that you can tolerate, locating your workstation to a different place away from printers and photocopiers, installing wired technology, etc. It may happen that you cannot be accommodated. It is possible that in some circumstances you cannot be accommodated. For example, if you are a painter and you react to paint, your employer cannot accommodate you. But if you became sensitive because of the paint, it becomes a CNESST case, and you could be eligible for disability or a retraining for another job. Or if you are working with certain chemicals, such as in a body shop fixing cars, and you have developed sensitivities from the exposures, again, your employer cannot accommodate you. Or there could be instances where all attempts at accommodations are not successful and you are getting sicker. You may have no option but to leave your job and pursue the kinds of support mentioned above, such as employment insurance, salary insurance, etc. Now we will discuss other accommodations. A service provider's obligation to accommodate. In principle, a supplier of services has an obligation to accommodate you, just like an employer. A supplier could be a supplier of public services such as a government agency, school, university, or public transport. A supplier could also be private, such as a restaurant, a movie theater, or someone who provides services in your home, such as an electrician, plumber, etc. In other provinces, there are hospitals, schools, universities that have scent-free policies. Unfortunately, this is not the case in Quebec. It is time for Quebec to join the ranks to provide scent-free environments in all healthcare settings, schools, universities, etc. If it can be done elsewhere, why can't it be done here in Quebec? After all, it is a basic human right to breathe clean air and also to a healthy environment. Again, I refer you to the sample letters on how to request accommodation. In principle, the owner of apartments for rent, just like an employer, has the obligation to accommodate the needs of his tenant. This obligation cannot go beyond undue hardship to the landlord. A strategy for a tenant who has environmental sensitivities would be to invoke a right that is in the Civil Code of Quebec for all tenants, which is to peacefully enjoy housing during the duration of a lease. For example, in many cases, if a tenant can prove that a serious prejudice has occurred due to cigarette smoke from another tenant, the Régie du Logement or the rental board will authorize to add a clause or article of non-smoking even during the existing lease. This ruling will not apply if the smoke comes from an apartment that does not belong to the same owner. In order to have your rights as tenants, it might be useful to contact groups that are for the defense of tenants. These groups are welcome to contact us for more information about your condition or environmental sensitivities. Remember, you must exercise your rights within the time frame provided by law. For more information on the available resources and deadlines, contact your local authorities or non-profit groups who deal with housing rights. If you live in Quebec, you can contact us, but if you live elsewhere, it is important that you find out your rights as a tenant from the rental board and other similar authorities. The right to dignity is the right not to be harassed by others because you are suffering from environmental sensitivities. Just like any other disability, people suffering from environmental sensitivities have the right to be accommodated and the right to be free of harassment in the workplace and any other place. We know that many people who suffer from environmental sensitivities are not taken seriously, are not believed, and are subject to hostile behavior. Why do you think this happens to people who suffer from this condition? Perhaps it is hard for people to accept that products that they think smell good are not necessarily good for your health. Publicity tends to associate perfumes and perfume products with beauty, desirability, happiness, miraculous transformation of something that has rotted, for example, Febreze, into something new, clean, and acceptable. So it is a big step for the general population to consider these odors as toxic substances. Also, the person suffering often looks or appears to be in good health. Often there is no physical sign of disability, such as a person in a wheelchair or someone who is blind. If a person cannot perceive a physical manifestation of the problem, it is easier to deny its existence than to believe in it. As science uncovers the effects of chemicals on humans and the planet, more and more people are being advised to avoid certain chemicals and products. The request for accommodation for people suffering from environmental sensitivities is sometimes viewed as just another demand on the public to narrow their personal choices. Also, people tend to express their identity and individuality by the clothes they wear, their hairdo, and also the perfumes that they wear. So to tell them that they are invading the space of others with the affirmation of their identity is often perceived as a personal attack, just as it was for smokers years ago. The person who is suffering is in a very difficult situation. Perfumes and other products are everywhere in our communities. The constant request to be accommodated is viewed as the sufferer being difficult and hard to please, when in fact, the sufferer is only asking that co-workers or people around them change the products that they use so that they can live in health. And it's true. To accommodate someone and to be good to yourself, you must change your choices. And often people are reluctant to change. In addition, people have a hard time accepting that they are damaging someone's health with something that they are absolutely fine with and find so normal in their environment, until they get ill themselves. Then the story changes. This has been our experience in the association. In your opinion, why do you think this illness breeds so much hostility? We look forward to hearing from you. What is harassment? Harassment must be repeated harassing gestures such as making faces, using derogatory words and gestures that create a negative workplace environment, or a serious act such as deliberately exposing the person to scents, which adds an additional harmful exposure where the person works. Harassment at work. Know your rights. An employer must try to prevent harassment. If there are complaints of harassment brought to the employer's attention, the employer must stop the harassment. Like in any other workplace management, it is a good idea to keep a record of all harassment, preferably verified by a witness or other evidence. Remember, the Charter of Rights prohibits harassment of a person with a handicap. Since environmental sensitivities are recognized in the Charter as a handicap, it is prohibited to harass people who suffer from this condition. Remember, do not give up your search for a doctor. Do not give up fighting your case. Build a strong support team around you. Keep records of your exposures and symptoms. Always communicate your need for accommodation in writing. For help on implementing a scent-free policy, visit this website. Here are a few resources to help you make your claim to the CNESST if you are not unionized. Find out such resources in your area. We hold workshops on environmental sensitivities in French and English, which we can give online no matter where you are. These workshops are to empower the individual suffering from environmental sensitivities, and they cover the biological, social, and legal aspects of environmental sensitivities. Contact us and register for a workshop. Please visit our website for more information: www.environmentalsensitivities.com. Do you know your rights as a person suffering from environmental sensitivities? If you don't, you should. This is very important to make sure that your dignity and your handicap is respected and accommodated. Now that you have heard some information on the subject, we hope that it will change your viewpoint, lift your spirits, and help you to be the best you can be. I hope this presentation has helped you or will help someone you know. It is very important to know your rights. Often one is tired and unable to do all the things that need to be done just to get by from day to day. If you are in this state, find someone to help you. There are volunteer groups and you can work by phone and through emails. You don't have to meet someone in person to get help. If you know of others who have just come down with this condition, please share this information with them. Also share this with family, friends, your doctor, lawyer, building manager, etc. Spread the word. If you need help, contact us. We thank you for listening to this presentation. We thank the project When the Environment Makes You Ill, Need to Understand, Need to Act, A Question of Legal Rights, found on our website at www.environmentalsensitivities.com. We also thank Dr. Margaret Sears and our sincere thanks to Mr. Claude Renaud for translation.